Hello, my name's Rachel Okello and I'm a UK-based solicitor specialising in immigration, nationality and deportation law. I've been a solicitor since 2002 and since 2007, 90% of my caseload has been just helping people who want to live, work, study, join family or do business in the United Kingdom. Today I want to talk about the changes in the immigration rules. And I want to take us back a little bit. Now is 2017. I want to take us back to 2012. And the reason why I want to talk about the changes today and the new rules, which are not that new, but they're 5 years old as we speak. But the reason why I want to talk about the rules is because I find that a lot of people, and I speak to hundreds of people over the course of my daily activities, I find that a lot of people don't understand and they don't grasp exactly where UK immigration is today. And when you explain to people the immigration rules and just how harsh those rules are, they go away quite not being convinced. So I just want to break down today what the immigration rules are, what the changes are, and how can you, in today's current immigration climate, harsh climate, achieve your goal of living successfully and legally in the United Kingdom. So the first thing I want to look at is the rules for families. And that's primarily what I'm going to look at today. So if you are in the United Kingdom and you want to live a family life here, you can do that in certain circumstances. So you may have had a visa to come to the United Kingdom to work, and within that you're able to bring your dependents with you and to obtain indefinite leave to remain that way. But if you came just for the purposes of family life, then the law is very clear that that family life must be seen to be genuine, and also it must be seen to be that it can only take place in the United Kingdom. What the Home Office will ask you is, why can't you live that family life outside of the United Kingdom? And so that's one of the things that you need to deal with when you're trying to explain to the Home Office why your application based on family life ought to succeed. You should be able to explain to them with evidence why your family life can only continue in the United Kingdom and why it can't continue in your country of origin. Looking at somebody who then is married to a British citizen and wants to obtain leave to remain on the basis of their marriage to a British citizen. And in this category, you don't have to be married to a British citizen. You can also be living with a British citizen in a relationship akin to marriage, which the minimum time scale that you'd need to be living together is 2 years. And it can also be somebody who has indefinite leave to remain. Even if they're not British, they can have indefinite leave to remain, and that application can work within the same rule as well. So you'd need to show why, if you're already in the United Kingdom, you shouldn't have to abide by the rule and leave the United Kingdom to make the application from your country of origin. So what you would do is you would decide, for example, that you're going to make an application on that basis, and if you are already in the United Kingdom, the Home Office would expect you to leave the United Kingdom and make the application from abroad to re-enter. Seems like a waste of time, actually, to be fair, but to re-enter the United Kingdom and start on your what we call the 5-year route to settlement. If you can show exceptional reasons why you shouldn't be made to leave the United Kingdom, even temporarily, to make the application, then you have a chance of the application succeeding in the United Kingdom, from within the United Kingdom. But what I will alert you to is the fact that you'll be put on the 10-year route to settlement. So instead of it taking you 5 years to get indefinite leave to remain, it'll actually take you 10 years to get indefinite leave to remain if you apply from within the United Kingdom. So you'll balance that when you're thinking of what you need to do. And particularly if you don't have permission to be in the United Kingdom, so if you're what we call an illegal migrant or an overstayer, then it is very difficult to use your marriage to a British citizen person to say why you should be allowed to stay in the United Kingdom. And that was a deliberate act of the current government to say that people who have overstayed their visas shouldn't benefit in the same way as people who, as they say, have played by the rules. So particularly if you have overstayed your visa and you want to apply to stay with your British citizen partner or somebody that you lived with for at least 2 years, and who could be British or have indefinite leave to remain, then you would need to provide the strongest possible evidence as to why you should be allowed to make that application from within the United Kingdom. And another thing to remember as well and to bear in mind is that if you are making the application as a spouse or a partner from outside of the United Kingdom, then you will have to fulfill the minimum income threshold as well, which you won't have to do if you make the application from within the United Kingdom under those exceptional circumstances. So that's another factor of you thinking, well, if I leave the United Kingdom, it shouldn't be the only factor, but it's something to bear in mind, that if I leave the United Kingdom, I know that my spouse does not earn the minimum income threshold amount, then I know that my application will fail if I leave. So you need to get some clear advice on your options in those circumstances. The other category I would like to look at as well are children. Now, in years gone by, the rules have fluctuated regarding children, and very long time ago, if you were born in the United Kingdom, you could be British and you could stay here. That's changed. It doesn't mean if you're born in the United Kingdom that you are automatically British. You'll take your nationality from your parents, and so you do need to bear that in mind. Your nationality will come from your parents and your grandparents, and so you need to bear that in mind. I want to talk about children who were either born here and are not British, or have come here from abroad and have lived in the United Kingdom for some time. So the rules would say that the minimum time they would expect a child to live in the United Kingdom, if they want to benefit from their time here, would be 7 years. And in years gone by, we could just simply write to the Home Office and say, well, this child has been here for 7 years. Can we have the papers for them and their family, please? And the Home Office would oblige, and it was as simple as that. That has now changed. Under the rules, a child will need to be in the United Kingdom continuously for at least 7 years. And in addition, if you want to show why that child should be allowed to stay here, should get their papers to live here and their family, then you will need to show exceptional circumstances. You will need to show why it is not unreasonable to expect the child to return to their country of origin. So this is a child who's under the age of 18, and as we know, children are very adaptable. So it'll be very difficult for you, and you'll have to really get that evidence and show why, although the child on the face of it does fit the rule, the 7-year continuous residence rule, but the additional test that you have to show is why it's not unreasonable to expect that child to leave the United Kingdom and go to their country of origin. Can that child return to their country of origin and live there with their family? Would that really be so detrimental to that child that the government should allow the family to stay in the United Kingdom? So that's what you'd have to show. Another more simpler rule, I would say, is the long residence rule for people who have got over the age of 18. So people between the age of 18 and under 25. So you can't be 25, you've got to be under 25, so 24 really. And if you can show that you have been in the UK continuously for half of your life, and you're between 18 and 25, then you can make an application for leave to remain in the United Kingdom. And I think that rule really, it's quite a good rule and a fair rule, because a lot of young people have found that they've been in the United Kingdom for a long time. They're now adults, so they're not necessarily dependent on their parents, but their parents brought them here when they were very young, and they find that when they go to college or university, particularly college, that they ask for their papers and they don't have those papers. And so if they can show that they have been in the United Kingdom for at least half of their life, then under the rules, they can apply for leave to remain, and they will be put on the 10-year route to settlement, so 10 years before they get their indefinite leave to remain. So for people who are over 25, the rules have changed significantly. In the years gone by, you'll remember, many people, that if you'd been in the United Kingdom for 14 years with lawful residence or without lawful residence, then you could apply for your indefinite leave to remain. So again, that changed in 2012, and they bumped it up to 20 years. In addition to bumping it up to 20 years, you will no longer automatically get your indefinite leave to remain. In fact, you won't get indefinite leave to remain. You'll be put on what's called the 10-year route to settlement. So it's that same old 10-year route to settlement, 10 years of lawful residence before you can apply for your indefinite leave to remain. So the actual old time 10-year route to settlement is still in place. So if you've been in the United Kingdom legally for 10 years, you can apply for your indefinite leave to remain. And that's where the government wants everybody to arrive. They want everybody to arrive at the same starting point so that they can obtain 10 years lawful residence, and then they can apply for leave for indefinite leave to remain under the long residence rule. So that 10-year lawful residence rule is still in place. The 14-year rule, where you had some lawful residents and some unlawful residents, that's been changed. That's now 20 years. So if you've got some unlawful residents in the time that you've lived in the United Kingdom, then you will have to acquire 20 years of continuous residence in the United Kingdom before you can apply for leave to remain and be put on that same 10-year route to settlement. And settlement means to indefinite leave to remain. And I need to alert people at this point that time spent in prison is not included. Time spent in a reporting, if you're reporting and you subsequently obtain leave to remain, then that can be included. Okay, so I wanted to really break down to people today so that they can understand better and make better applications and know what evidence they need and what applications they can make and can't make. Because I sometimes talk to people and they don't realise just how harsh UK immigration has become. And you need to understand that so that you can make the application that fits your circumstances and have a better chance of success. And even if your application is not successful, you'll have a better chance of challenging the Home Office before the Immigration Tribunal judge. So I hope that's been of use, and do keep in touch, connect with me and follow us on Facebook. We're at Rogol's Immigration Experts. We're also on YouTube at Rogol's, which is ROGOLS. Website is rogols.co.uk, and you can go to our contact tab and you can book a free immigration case assessment, or you can simply call the office on 01213 894 895. If you prefer WhatsApp, then it's 07895 327 049, and book your free immigration case assessment, which we will do for you at no obligation. You don't need to instruct us further if you don't wish to do so, but it's just so that you can proceed in confidence, knowing what application is likely to succeed and what isn't. And that's going to save you a lot of time, headache, and money. So thank you, and keep in touch.